system.
You've used the word conflict quite a bit. How are you defining that?
I define it the way that Hannah defines it.
How about Shady
Even
Grove?
Shady Grove. That's actually a great case.
Answers the same question. Yeah, that's different than.
It answers the same question, but the court made clear the two could not coexist at all. The trial court in Shady Grove.
Well, just because they were different.
Not just because they were different, Your Honor. Remember, in Shady Grove, the case was dismissed at the outset on a jurisdictional ground because the court said, I can't use the class action device at all to package claims together and meet the amount in controversy requirement. So it was a ruling that said, I can't even look at Rule 23. That was a conflict. There was no way at all to apply Rule 23 the way that the trial court had applied it there. That was an unavoidable collision, answering the question in dispute in a way that required displacing state law in Shady Grove. So we're using the term conflict or collision in the same way as the court was using it there.
And you don't think, or do you, that conflict encompasses when they're just additional requirements?
I don't, because Walker tells us that's exactly how you don't read conflict. It said.
Well, but Shady Grove says additional requirements. I mean, that's in Shady Grove on 401. You're right. I mean, obviously, Shady Grove struggled with Walker. It's in one of those classic footnotes. So I take your point on Walker. But in the text of Shady Grove, it was talking about additional requirements, at least as I read it.
Well, the way I understand.
And that, in turn, would answer the same question, which was the test Shady Grove set, which was a little more refined than the prior tests, at least as I've read it all.
I think Shady Grove didn't do away with the requirement that the conflict has to be real and actually presented in order for federal courts to just do away with state statutes in their entirety in federal court. I think that much was true of the New York statute in Shady Grove. And it's been true in other cases too. Semtec, which interpreted Rule 41, it said, well, we could apply this to preclude the state law of claim preclusion, or we could apply it to incorporate the state law of claim preclusion. There it wasn't an on-off switch, and it wasn't we can apply one or the other. The court said, no, we apply Rule 41, but we do so in a way that preserves the substantive state law of claim preclusion. So that's the difference between sort of the Semtec example and the Shady Grove example, where there's just no way to reconcile the two.